sufficient to meet the requirement to establish procedure and practice of the Supreme Court?
I would say it is if the notion of appeal.
Whereas the same powers is being enjoyed by the High Court and the Federal Shariat Court under Article 202, 201 and 2 and Article 203J. What are those requirements which prompted the Parliament to constitute this Act?
I would not like to, because a lot has been said as to why Parliament did it. To me, the central issue is whether Parliament had the constitutional authority.
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत इस वक्त जारी है। आप ये मुलाहजा कर रहे हैं बराह रास्त मनाजर सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के हवाले से। आपको मजीद ये भी आगाह करते चलें कि आज ही इस केस पर कोई फैसला आने का इम्कान जाहिर किया जा रहा है। इससे पहले तमाम तर जितनी भी पार्टीज थी इख्तलाफ में और इसके हक में वो अपने दलाइल मुकम्मल कर चुकी हैं।
Exercise of another constitutional power is unconstitutional. I mean, Parliament can tomorrow maybe exercise that also. वो उस वजह से तो नहीं हो सकता।
Same authority is being used by
Yes,
two other
yes,
courts,
yes, yes.
but specifically it is done with the reference to the Supreme Court.
But exercising one kind of power is not barred by not exercising another kind of power. But the real issue is whether Parliament has this power and to what extent does it have
Just
this
to resolve this, Mr. Attorney General was repeatedly asked to bring the record of the legislation.
Maybe he
Perhaps
can
that has
answer
not
that.
been-
He is in a better position, sir. But I take your lordship's question.
There's one more
Ji.
question on the jurisdictional or jurisprudential plane. Basic principle is that an appellate forum or right of appeal is provided by the statute which confers the jurisdiction in the first place. Right? Right or wrong?
Not an absolute rule.
Okay. A statute doesn't provide an appeal. Another statute can provide, on the same footing, it can provide an appeal. Or an amendment in the statute can provide an appeal. Here, the jurisdiction creating statute or instrument is the Constitution. If a right of appeal is to be provided, it has to be provided by the Constitution, not by sub-constitutional legislation. Because the effect of sub-constitutional legislation would be that you would be conferring the powers on a sub-constitutional instrument to provide such appeal. Is that doable jurisprudentially?
My lord, the position which I have stated before your lordship, and then I'll move on, I'll just state, because I'm very conscious of the fact that your lordships have taken a different position in the Ghulam Muhyiddin case. I will deal with that judgment when I come to that. But my position is, number one, if this appeal under this statute is unconstitutional, then the appeal under the law reforms ordinance is unconstitutional.
मैं सिर्फ प्रिंसिपल आपसे
मैं इसीलिए मैं प्रिंसिपल की
वो
बात
इफ तो ठीक है आई मीन उसका जवाब तो ये है वन दोज मैटर्स आर नॉट बिफोर अस टू रॉन्ग not make
and the appeal under the contempt of court ordinance has been upheld as constitutional by this court.
yes
That is
Under
also an
different
intra-court appeal by a
circumstances, under
statute.
different circumstances and for different reasons.
जी
मैं आपसे ये पूछ रहा हूँ कि ये jurisprudential जो प्रिंसिपल है कि आप किसी और स्टैट्यूट से which is not on the same plane as the original statute which conferred jurisdiction, आप right of appeal provide कर सकते हैं considering that it is a substantive right. So by sub-constitutional legislation, can you exercise the same powers as are envisaged in the Constitution, i.e. creating a right of appeal?
My lord, your lordship,
Ignoring the fact that the instrument that creates the jurisdiction does not provide an appeal.
My lord, I think the instrument which creates the judicial forum in the first place is irrelevant. The issue is whether that particular provision has a bar to creating such an appeal through an ordinary statute, number one. Is there any bar in Article 185 that such intra-court appeals cannot be created? What I'm trying to understand, where does this bar come from?
From the language itself, subject to
language?
the constitution and the law. You see, you're relying on this language to say this is enabling and this gives competence. But there are other language where the constitution gives enabling powers to parliament and gives it competence. It's totally different language. So you are not creating any difference in that language. You are not saying that where the constitution is saying it may by law or it may by or under any law, which is a direct power that it is giving to the parliament, you are not making any distinction there. You are just saying read competence into the word law. The word law has been used over 400 times in the constitution. Do we read competence into every word law is used, or do we now start distinguishing yahan law ka kuch matlab hai, yahan law ka kuch aur matlab hai? That's why for interpretation you follow principles. So which principle are you following? And on what principle will we be able to say in the next case and the next case that this is the principle that we followed?
I think these are two separate questions. Your ladyship is still on the question of competence. The judge has asked a question regarding procedure. These are two separate questions which should not be
separate. It's the same, and it goes
separate.
back to Justice Shahid's question as to the manner in which any change in the jurisdiction given by the constitution
Where is the bar in the constitution which says that a constitutional forum created by the constitution bars the statutory remedy? Where is the bar?
Achha, can you cite any example where the jurisdiction creating statute does not provide an appeal, and by way of subordinate legislation an appeal has been provided? Or to extend the example further, through another statute which is not on the same plane, an appeal has been created.
My lord, your lordship doesn't have to go to statute and rules. Your lordship just has to look at constitutional forums and intra-court appeals. Intra-court appeals.
That is precisely the point.
I think 270, Article 270 is answer to the question where the constitution maker has upheld the jurisdiction of the parliament to enact by providing to the Supreme Court. देखिए इसमें 270 में प्रोटेक्शन दे दी गई है।
No, but
इसका मतलब है उसको प्लीज सर ये है ना कि उसमें वो अपील की रेमेडी दे दी गई है, उस अपील की रेमेडी को अपहेल्ड कर दी।
My brethren, to let's one speak at a time.
Where jurisdiction has, original jurisdiction has been created, conferred by the constitution. Can sub-constitutional legislation interfere in that? And
yes, if there is no bar, and
no,
it can.
There is a bar. The bar is item 55,
and there
which says express authorization. Now we have repeatedly asked you, where is the express authorization? 175(2) doesn't cut it.
My lord, I have stated 170.
During the break, I went through the LPG Association against, and I stand wiser actually. I think 175 could grant that authorization.
Yes. So that is, I've stated that. I take your lordship's point. Maybe I will elaborate it when I come to your lordship, and I have the very difficult task to argue against the judgment.
Please proceed.
Please read
with a very heavy heart.
Article 270. Please read it.
जी. Then मैं move on so that I finish, sir. I know your lordships are temporary validation of certain laws.
As a side note, since you represent a political party, did anyone vote against this, any political party vote against this law?
Sir,
if you don't know the answer, you can give it later.
Attorney General,
No,
Senate में भी थी.
आपके clients बता सकेंगे ना?
नहीं, मेरे clients ने तो voted for that.
नहीं, actually,
yes, I can ask if I didn't ask. Sir, I'll move on to the next, but I'll come back to and your lordship's question was.
270. ये आर्टिकल 270 आप पढ़ रहे थे।
जी सॉरी, Majlis Shura may by law in the manner prescribed for legislation for a manner impact part 1 of the legislative list validate all proclamations, presidential orders, martial law regulations, martial law laws and laws made between 20th 5th of March 1169 and 19 day specific कोई section आप
So law, the law reforms ordinance, the power of making law has been protected by Article 270 by the Constitution.
जी जी
तो जब एक मर्तबा वो power Constitution ने कहा कि ठीक है,
सर ये retrospective protection है,
फर्दर के लिए दिया है।
पोस्टपेक्टो अप्रूवल थी भाई,
फर्दर भी उसको आज तक यूटिलाइज नहीं पाओ।
I take your point. I'll move on to the next point. ठीक है? Sir, there I think, and this is where I differ from Mr. Salahuddin Ahmed, I think there are two principles which have to be safeguarded in the context of the constitutional history of this provision, where slowly all executive role has been taken away. This is not happening here. The executive role is still there in 145. But here, and the structure of the provision itself, where the dominant focus in the Supreme Court making rules. There are 4 limitations on the Parliament making laws regarding practice and procedure. Any act of Parliament under Article 191 Constitution 1973 will be subject to 4 restrictions, limitations. Firstly, the law has to be limited to practice and procedure. Secondly, the law cannot colonize or abrogate the primary role of the Supreme Court to frame rules. So if your lordships come to the conclusion, I don't support the view that Parliament can simply abolish the Supreme Court rules. That will destroy the complete autonomy of the Supreme Court. But if you
can there be an implied repeal? Mr. Salahuddin took the position that can be expressly repealed. Can there be an implied repeal?
There can be implied repeal, but does that amount to destroying the power of the Supreme Court framing rules? That has to be seen provision by provision.
There can be implied repeal. Why can't there be express repeal?
No, there can be express repeal in relation to specific provisions. The third.
So what you're saying is that if there is a rule is made and subsequently Parliament can undo that rule by making a law, so then the law will prevail.
Not in every circumstance. And I'll explain. When I read
how does that then, how does one understand this second point of yours?
By the third point.
It does not abrogate the role of the Supreme Court.
By the third point.
Which we are awaiting to hear.
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत इस वक्त जारी है। आपको आगाह कर रहे हैं कि दलाइल आज अगर मुकम्मल हो जाते हैं तो आज ही इस केस के ऊपर फैसला महफूज किए जाने का भी इम्कान जाहिर किया जा रहा है। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत इस वक्त आप बराह रास्त मुलाहिजा कर रहे हैं, जो कि टेलीकास्ट की जा रही, ब्रॉडकास्ट की जा रही है। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के हवाले से आपको ये भी आगाह करते चलें कि आज इम्कान जाहिर किया जा रहा है कि इस हवाले से कोई फैसला महफूज किया जा सकता है।
इस्लामाबाद सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों पर समाअत जारी है। चीफ जस्टिस पाकिस्तान काजी फाइज ईसा की सरबराही में फुल कोर्ट दरखास्तों पर समाअत कर रहा है।
At the heart.
That's a separate thing.
Learned Council.
They're two separate things.
Separation of powers restricted to the judiciary.
Yes.
What if the judiciary starts encroaching upon the powers of the legislature and executive?
पांचवा डाल दीजिए,
and
क्या
that
फर्क
is
पड़ता
how
है? पांचवा डाल दीजिए, क्या फर्क पड़ता है? कोई फर्क पड़ता है?
So can I mean there's a system of checks and balances as well.
Yes.
So the Parliament is empowered to legislate, and all that they have legislated is something which ensures to justice.
That is what I will show when I come to provision by provision, that none of these provisions.
Can you elaborate a bit more on your second one? The court cannot colonize or abrogate the primary role of the Supreme Court to frame such.
My lord,
Kindly elaborate a bit more.
Example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, the Contempt of Court Act 2012 did is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of for example, a contempt on the face. In that, legislature interfered and that said that case will go before another judge.
That's not practice and procedure. That's not
No,
practice.
but I'm saying that is that.
No, but Baz Kakad was decided in the context of Article 204.
No, I'm giving you an example.
But that was a different context. Give me an example of 191 when you say.
I'll give you an example.
Colonize or abrogate.
I'll give you an example. Let's take section 2. If there was any role.
आप जरा specific example नहीं मुझे जरा पहले इस principle को जरा समझाइए.
वही मैं principle.
आपकी limitation
मैं एक example से principle को. Let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I would say would be a violation of 191 and the principle of the independence of the judiciary.
I would regard section 2. I mean section 3 actually.
Section 2 sir committee जो बनती है एक committee member chief
3 में है ना
जी 2 में है ना 3 में तो वो है ना sir maintainability वाला sir.
Sorry 2 में है. I would regard that as colonizing the.
I know your lordship comment about.
You used very interesting words.
Colonize.
तो colonize.
बस ये literature पढ़ के थोड़ी सी गलत
हो गया ना इसको. इसलिए मैं आपसे ये you're making an interesting point, but I want you on the plane of principle kindly to this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggested that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
The other way is that you keep the door open, but the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddiqui sahab, ये जो आपने बात की है second, ये आपका जो second है, how does that square with the implied repeal? आपका ये जो second point है ना? Secondly, the court cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible. Kindly explain to me how. As a principle की बात करें. I mean, don't go into the nitty-gritty right now. वो तो आप आगे जाके. How does this square with? You say there can't be express repeal, but how does this square with implied repeal?
No, sir. There can be express and implied. What Mr. Salahuddin argued that the Parliament can get rid of